All right. So 6 o'clock, Brian. How are you today?
I'm doing well, but I realized that I haven't done two things for us, Sam. One, put up that graphic, and two, put up that little logo that is now floating above your head. But I'm
Nice.
feeling a lot better now about the
Vacation was
universe,
good.
Sam.
Enjoy the vacation.
Yeah, I was off for 2 days, doing a little bit of traveling with my wife, and pretty good, pretty
Vacation is
good.
good.
We found
Balance
some nice,
between
some nicer weather is the bottom line, you know.
yeah, balance between vacation and I'm gonna fix that camera. I think I'm a little too low here, Brian. Sorry about that. Okay, balance between the vacation and the work is a good thing. All right. So, how to prepare for new H-1B rules from the law firm of Shihab Burke. Little introduction. We are an immigration law firm in Dublin, Ohio. We practice immigration law in the area of employment immigration law and the area of family immigration law. We are dedicated to this practice and have attorneys with double and triple decades in the business. And we would love to talk about today how to prepare for the new H-1B rules that are coming soon, Brian.
Yes,
So,
implementation
how to
effective.
prepare?
Yeah,
Yes.
Friday, January 17th. Yeah.
And with me is my partner, Brian Burke.
Yes, I am. I am here. I think they would have eventually noticed me, but I would have eventually spoken up. But yes, yes. So we have new H-1B rules coming on effective Friday, just prior to the end of this administration. And maybe Sam, I want to give my executive summary because, as done in the past, I've showed off. I have a nice copy of the rules here. I know you've been reading them online. I prefer to do these things in an analog way. But my summary of the rules is that USCIS says this is pretty much the status quo. We're maintaining the status quo. Nothing's really changing. We're just codifying what we can do for the most part already, with, in their mind, very few substantive changes. You know, and my take on that is I'll believe it when I see it, because when you read a set of new regulations, USCIS is forced to comment on all the comments that have been made about the public has made about them. And I would say the overarching summary of all those comments that I've read is, hey guys, why are you codifying these things? Because here's what's going to happen. USCIS officers are going to run rampant with the power that you're codifying, and they're going to interpret it to mean meaning you must request contracts, you must contact the end client, things like that. That's sort of the big one. One of the things talked about this is USCIS, and I think I'm going into it substantively, Sam, a little bit, is that USCIS codifies that we're allowed to request contracts from petitioners for
And
H-1B
clients.
visas and requesting contracts with those end clients. And literally, it says in here, we always had the authority to do this, but we're codifying it right now. And so many commenters say, whoa, 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 officers are going to go crazy with that. They're going to start requesting for everybody. And USCIS says, no, we don't expect it for every case. We don't think it's going to be necessary for every case. But I'm going to tell you about something else that officers went crazy with during the last version of H-1B regulations. An employer must have the ability to the hire, fire, and otherwise control the beneficiary to establish an employer-employee relationship, right? And even though I was arguing from pretty much day one of doing this job, it doesn't say hire, fire, and control. It says one of them, right? And I would argue that all the time on the RFE responses, and they would go, "Screw you," and officers just basically, if I guess the point I'm making here, Sam, is when they get a little bit of a nugget of a little bit of anything of power in the law, they will bend it so far out of shape and abuse it. And I don't think it's crazy to think that they can potentially abuse these regulations coming in and turn power into standards, to basically say, you can never meet the preponderance of the evidence standard without giving us contracts, because it says we have the ability to get contracts, because they do things like that, in my estimation.
So you believe that H-1B filing is going to get now more difficult with bigger RFEs and more documentation?
I mean,
What
I
about
mean,
the deference standard? So it's another change,
yeah,
and it's not a change. It's a change where it was done by policy, and now it's in the regulations, etched in the
yeah,
regulations, meaning that if there's a specialty occupation established in this position, prior deference should be given to the application based on prior approvals.
yeah.
Now my screen is twitching. Brian, is your
I see
screen?
that. My
Okay.
version of you is twitching a little bit as well. I'd say we give it a few. If we see it twitch again, there's that twitch.
Yeah.
Um,
So I have used a cable that looked old to me on the stupid camera. That
Find
I'm
yourself
worried that
a
maybe,
USB extender or something like that.
yeah, it's an old cable, so maybe
Yeah,
that's what's causing it. If it doesn't do it, I'm gonna go off and then unplug and plug it again
it's not too.
without the cable.
It's not too. Okay, it's a little bit little bit disruptive. It looks like you're stuck. You're trapped on the internet and need my help in order to get out of there. That sort of thing.
Yeah.
Very
Right.
sci-fi.
All right. So I'm gonna go off. Brian, you pick it up. I'm gonna see
Okay.
if I can fix that, and I'll be
All
back.
right. Well, if we're going to leave Brian to his own devices, and oh no, you can see the stuff, the junk I have on my desk behind me. I'm going to go through everything. I'm going to start talking about everything they say that they are changing here from their opinion. One, amended petitions. They said they're codifying the requirement that's put forth in the Simio Solutions memo that a change in work site is going to require an amended petition. For me, that's not a big deal. Everybody knows that already. Everybody is largely compliant with that. Deference is on the list. As to what Sam said, was just talking about, deference is on the list. Bottom line is, I don't buy any change or positive impact or negative impact regarding deference. I find that if USCIS is going to defer, they're going to defer. If you're finding yourself in a spot where they're challenging you, it means they don't think they have to defer. And that's that. And there's never been a scenario where, and I'm not criticizing myself, my skills as an attorney, but I'm saying that if I'm finding myself making an argument saying you should have deferred here, we're already off the deference train. They're going to decide whether or not they're deferring. And if I say no, you really should have, I don't think they care about that.
So, but it's a big deal because in the prior Trump administration, they have done away with the deference standard,
Sure, yeah,
and
by
now that
policy,
we're
by
getting,
that's the distinction. That is the important distinction to be drawn here. Basically, it was a policy that was sort of not written into the regulations, and now they have an H-1B deference policy baked into the regulations. So I
and that's
guess,
huge
well, it is
on the upside.
okay. It's huge on the upside, right? But I would say, okay, we've determined we made it. I mean, what's the standard for not deferring, Sam? You determined you made an error last time, right? That is what it is. I'm looking for the exact language here. Here it is. When there's no material error with the prior determination, right?
Yeah,
I
no,
think
not an error, a material error.
yeah. My problem is I think they're going to be really super inclined to find material errors a lot easier.
No.
I fully disagree with you on that one. We for them, material error is we made the wrong decision last
So
time.
they're gonna shoot themselves in the foot and say we're making errors.
Yeah, I think yes. I think they will have
Yeah, I'm
boilerplate
sure.
language for it, Sam.
I'm sure
I'm
that
fighting today, Sam. I was off for work for 2 days. I had a lot of fight and.
I'm sure it will happen sometime.
Mhm.
I don't think it's gonna happen by policy. But it's a crystal ball. You see it that way. I see it that way. I just don't. But the
Well,
bottom line is this, Brian.
sure.
We have now a regulation, so
Yep.
people understand, what we have. A regulation that gives deference to prior H-1B positive decisions,
Yep.
which help cases that are similar, like same end client,
Yeah.
same job,
Yeah.
same employer.
Yep.
You get a deference in
Yep.
that you don't have to worry about it.
Yeah. So
So that's the regulations.
I'm going to trade sides. I'm going to get on your side for a minute. I'm going to
Well,
elaborate. Yeah. Go ahead.
that's it. That's
Yeah.
it.
That's it.
That's the regulation. So people understand it.
Yeah.
People are not confused.
Yeah.
Now you can argue, and I can argue, and that's something that we can do forever.
Yeah.
That this is effective, will be respected, disrespected, overlooked. That's a different conversation.
Yeah.
But the
We don't know how
regulation,
it's going to go.
trying to tell people what has changed, that has changed.
Yeah.
That's it.
Yeah.
That's what we're saying.
Yeah.
Go ahead.
Yeah. So I guess, well, Sam, I have to give us a little bit of criticism. Our subject is how to prepare, right? And how do you prepare for a change in difference policy? I guess ultimately the answer is go. That feels pretty good, because
Yep.
you really can't you can't really complain about it until it negatively impacts you. And
Yep.
I guess the whole point of that, why it's good to have a regulation, means regulations can't be overturned as easily as policies. There's policies that can be ganked back in a minute. A regulation requires them to re-regulate to get rid of it, and that's sort of very important with the incoming administration,
Yeah.
right?
So for people understand, the policy is somebody sits down and type a letter,
Yeah.
signs it,
Yep.
and publishes it.
Yeah.
It becomes a policy. It's very simple.
Yeah.
A regulation is a you post it on a government document called the Federal Register. You go through rulemaking process. You give people an opportunity to comment, and becomes really the law.
Yeah.
A little bit better law than a policy.
Yeah. Yeah.
Uh,
Yeah.
the next topic, Brian, is the cap exempt H-1B extension for those who are on H-1B cap.
Yeah.
And these cap exempt H-1B extension, they used to hit October 1st, and the H-1B is not approved yet
Hmm.
and stop working.
Yeah.
And
Stinks.
now they got 5 extra months.
Yeah.
Okay. October, November, December, January, February, March, April. six
Yep.
months.
Yep.
Six
Yep.
months.
6 months.
And that is an excellent flexibility
Yeah.
in terms of working until USCIS make up their darn mind about the case.
Yeah, I agree. And I mean, the bottom line is considering how slow USCIS has gotten on H-1B adjudications, essentially the lack of a longer term cap gap was essentially a H-1B petition killer. If suddenly it's October 1st and you can't work, do I want you sitting around on your butt? If I don't have you now, do I really want you whenever they get around to approving this H-1B case? And that's can really be huge. I'm optimistic about that one, because it's gonna save some H-1B petitions that otherwise employers might lose
It's going to
interest in.
save some premium processing fees.
It's going to save some premium processing fees. Okay, Sam. So if our topic is about preparing for that, you're right. And people in our audience could realistically be doing an H-1B cap this year, and their employer is now disincentivized from doing premium processing. I guess one is understand that it means if your employer is disincentivized from doing it, you might be waiting longer for an H-1B approval, which means waiting longer to travel and all that sort of good stuff, I guess. Right?
Yep. Anything on your list, Brian?
On that, what do you mean, other topics to hit on the subject of the
Yeah.
of the changes? So I'm just
Yeah.
sort of going through. You were into the cap exemptions, but I'm not really into those, and that's a pretty niche topic. The cap exempt organizations.
Yeah, they're nuanced, very nuanced. So
Yeah.
we will not touch on that.
Yeah, so I'm going to maybe go down to contracts again. Um, Even though how they're going to implement it is unclear, it's very clearly written into the new regulations that we can request contracts, right? And how's it
Yeah,
going to
that's
impact?
a really, really a setback, in my opinion.
Well, again, USCIS says they've always been able to, but they also in their comments on these regulations say, well, we admit we haven't been really asking for that lately, but we're just sort of codifying our authority, right? And again, when USCIS says they have the authority, I don't know if I believe them when they think they have the authority, because they sure did stop doing it for, I don't know, a period from July of 2020 until present.
Well, they clearly don't have the authority. The court ruled against that.
Well, they think they've always it's in their notes here, Sam. They think they've always had it. So,
Whoever drafted it doesn't know what he's talking about.
well, yes, arguably so. So, I guess how does one deal with that fact? I mean, as the H-1B beneficiary, I guess you're kind of dependent upon, in a hypothetical IT consulting scenario, you're dependent upon your employer, your vendor, and ultimately the end client to cough these things up. right? The bottom line is, and this is something we've been talking to a lot of our employer clients about. It's getting the word out, because companies haven't had to give these things up for several years at this point, and some of them have gotten used to it. And I think it's really kind of getting that narrative, that into the narrative, because if you find yourself, let's say 6 months from now, we're in a climate where they're asking for contracts constantly, and you ask your end client, hey, I'm doing an H-1B, can you send a statement of work and a contract to the vendor, and authorize it to be sent to my employer? They might be that might come as a shock to them. I mean, the bottom line is, if you're capable of getting that dialogue started sooner rather than later, preparing for these things, if you tell somebody these things are coming, they have time to prepare for it. It's less of a shock, that sort of thing. If your employer doesn't file these things, if they're maybe not in tune to the H-1B news on the pulse of
Mhm.
it, bring
Mhm.
those things up with them as well. I mean, as our job as attorneys, we're bringing it up with our employer clients, but I can't say that everybody's doing the same thing. They must be surely talking to their clients about these things, but again, it's being primed and being ready, and to understand that, in the future, I guess, Sam, if you have two potential projects, two assignments, one of them is a client that's super mellow, understands the requirements, understands that a contract might be required, versus one that is, the response is no. I mean, it might help impact your decision making down the road in terms of what project to pursue with your employer.
The requirement for these type of documentation has never been fun, has always been cumbersome,
Yep.
has definitely made things difficult for everybody,
Yep.
uh, and is going to come back whether you know how to do it or you have experience with it or you don't.
Mhm.
It is going to be a problem for jobs where end clients is not willing to provide this documentation, and thus affecting. Um,
What's a viable H-1B position? I
yeah,
guess. I
yeah,
mean, that's it for the last couple of years. It's been really nice. It's, the end client won't give you anything. Who
yeah,
cares?
yeah.
Now you have to care about that again. And I guess companies who don't want to play that game, and clients who don't want to play that game, might not get the people they want. And those in that kind of has to impact your decision making. As if you're working as an IT consultant, you obviously have a say in it. And if you have multiple options, it's really
Well,
advocate for yourself in that scenario.
yeah. Not
Who's
only
the better
that, but
client to work with?
yeah, a lot of these contracts and languages are wishy-washy with 25 exit strategies for
Yeah.
the drafter, right?
Yeah.
Some of these master service agreement don't get auto extended or never get extended, and
Yeah.
you work on service, you know,
On a
um,
handshake, on a yeah.
yeah,
Yeah.
and so now you have to have a contract. It has to be written right. You have to review 25-page contract because USCIS is going to point to page number 15
Where something's wrong. Yeah.
that
Yeah.
says we can terminate without notice at any time,
Yeah.
and now all of a sudden you're getting 3 months H-1B approval.
Yeah. Yeah. I mean, let's talk about what the standard is. Used to be used to be the requirement was there must be a valid, employer-employee relationship, right? Now the standard is there must be a bona fide job opportunity, and that's part of the reason why they say they're going to be talking to they want to see documents from clients there. And bottom line is, yeah. I mean, that's
Especially
all.
when you're filing under H-1B cap.
Yeah. And
Those, yeah, and then 8 months later you bring the candidate, or 10 months later you bring the candidate.
that's the thing that's kind of going to be the most impactful, I think, for people who are new H-1Bs. If you're coming to the United States to work for a company and they've never employed you before, you know, uh, the USCIS position is, well, we don't want you companies engaging in speculation, bringing people over who you can't document work for. And my counterpoint is, all work is speculative. My work is speculative as an attorney. I know I'm going to be working as an attorney 6 months from now. I just don't know exactly what I'm going to be doing because I don't know who's going to need my services. And that's the sort of, you have to sort of, the government eventually, well, as a bunch of, we keep on calling ourselves attorneys because we're taking that leap of faith that we're going to still be needed in doing our work in 6 months. And USCIS effectively can't do that. It's again, that contracts thing is going to really impact your ability to get a fresh H1B, and that's again going to impact who do you choose to work for. If you have a lousy offer for somebody who seems to be more palatable to USCIS, versus somebody who doesn't. Maybe it changes who you choose.
Yep.
You know,
Yep. Absolutely.
I guess fundamentally, Sam, it can kind of keep smaller businesses out of it. It's if
Smaller guys going to be more impacted. Absolutely.
yeah, because we're going to trust, somebody who's a name we've heard of, who we trust. They have clients and they have business versus,
Yeah.
those, who we don't.
Yep.
So maybe Sam, if we're talking about preparing then for what to do, I think there's one last thing to bring up. It's the change on the beneficiary ownership aspect of it.
Your favorite case. So yeah, 51% or more, you can still do an H-1B
Yeah.
for yourself. That's a big deal. It's going to be very interesting to see how it's going to all play out, because the hiring and firing has to be divested, and you have to do at least 51% of the work related to specialty occupation.
Yeah.
And you get 18 months, and then the first extension, 18 months, and then you can get more
for 3
time.
years.
Yeah.
Yeah.
So that's a big change. I think converting H-1B to self-employment, I think for a lot of companies that might be, I don't know how aggressive it's going to be marketed and sold and purchased out there and if adjudicated, because because it could be a big deal.
Well, I was just sort of reading through USCIS's, notes and comments on, the incoming regulations, and they say, yeah, we're really kind of, encouraging this for, startups and entrepreneurs. And I can't imagine just being an attorney saying, okay, here's what we're going to do. We're going to start a business for you in the United States, and then we're going to do an H-1B visa for you. Okay, what are my odds of success on that? Well, if you get selected in the lottery, pretty darn good. But it's a lot of, if somebody wants to, I don't know, invest in the United States, I don't think they want to bet they're coming to the United States on
A lottery.
on a lottery system. No, I'm bringing big money, big business to the United States. And you're telling me it's a gamble. I'm in competition with accountants and school teachers and everybody else just because I'm in the same occupational visa group. It doesn't seem like a. I think anytime I'd have that conversation with somebody who's interested in H-1B as an entrepreneur, I'm going to say, well, this is going to sound a bit ridiculous, but you're literally in competition with people who aren't the CEO or CTO or whatever.
You can always do an L visa if they have a company outside, Brian.
Yeah, that's what I prefer.
This is kind of an added layer. So they got the E visa.
Sure.
That's available.
Yeah, I like O's for if you're lofty enough to start up a company. If you have a little bit of heat on you, that's out there as well. So you're right. I'm looking at it as
it's just an added dimension. But you're right. What you're saying is this is really not very practical.
It seems like you're right. So I'm looking at it very narrowly, and I think maybe you agree with me. It doesn't seem very practical. But if you're talking about every now and again, maybe once every week, 2 weeks or so, you talk to somebody who's wants to come to the United States, wants to figure out what's possible. I guess it does add something to that list. It's I'm still going to start with L's if you have a company out the United States. E's are awesome. O's if you got some heat on you, if you got a little bit of rah going on about you, and it's possible. If you toss your name get the business going, toss your name in the lottery, and you're a shoo-in because you're super
You're
qualified.
one out of 400,000 applicants, and
Yeah.
with about 10% chance.
Yeah.
Go ahead and spend about $80,000.
It seems very unentrpreneurial that I'm here to make it for myself. I'm pulling myself up by the bootstraps, but on this one I gotta be in the lottery.
I see your point, and I agree with you.
Now, Sam, I said one last thing, but here's the actual one last thing: site visits.
Big deal.
Site visits. They are no longer optional, and they are officially compulsory. You have to comply with them, and if you don't comply with them, they will basically say, well, gee golly, that's evidence of your non-compliance, and they're going to...
Yeah, we've talked extensively last time about it. I don't want to revisit it. There's a lot of problems with it, as we talked about, especially for those working from home.
Yeah.
You got people coming in with that unannounced to your house.
Yep. We want to see your work site everywhere you're going to be working. Do you work in your bed? Do you work in your bed? Do you take your laptop up to bed? We want to see your bed, realistically.
Don't take your laptop to bed. Then you can say no.
But sometimes now, there you go.
But yeah. So yeah, we recognize is a big problem in terms of privacy, the way H-1B workers a lot of time working from home. The training level of these officers sometimes seems to be below par in terms of their professionalism and knowledge and approach. So, with added power, that can be lethal in certain situations. So
Yeah.
we're gonna see some firework coming out of some of these interviews where they're just basically squeezing somebody unfairly and unnecessarily,
Well, on
uh,
the, yeah,
in an un-American way,
yeah. I mean,
and an illegal way as
on
well.
the sort of un-American unfairness, the H-1B worker doesn't sign up on the H-1B petition. The employer is signing them up for this. Oh, by the way, I signed a document that says you mentioned this last time that USCIS gets to come into your home whenever they want and sniff through your papers because you're on an H-1B visa. It's just it doesn't. You're right. It just un-American is the terminology that. On the bright side, you do get the right to have an attorney and you can have a representative from your employer talk. But somehow, I don't think this is not Miranda. This is not criminal law. I don't think they're going to be shouting that from the rooftops. And knowing USCIS, it's going to be a
Or
real
giving you a reasonable time.
yeah, real coercive situations. I mean, and it's fun. I like the
has
idea.
has always been that way.
Yeah, and that's and I'll close it on this. We're saying it's now compulsory. It was always compulsory in my book. If you close the door on USCIS, you're just going to get a notice of intent to revoke and say we couldn't verify any of the details. Thus we're attempting to revoke this, and you're still going to get that same result. Maybe they'll do it with I don't know more gusto. I don't know, but again, it seems like a net no change there. It was always compulsory to do it, if not in fact in practice it was. Yeah, yeah,
Good one, Brian. That's a good one.
yeah.
All right, so 627.
Yep.
Hopefully, we've given people feedback. I think we got some questions here. People who would like to ask some questions.
Yeah.
And just to let everybody know, we will answer those questions without establishing attorney-client relationship because we don't know enough about your case to give you an answer that's comprehensive enough that you can rely on. If you hear something here that is of an interest, seek an attorney of your choice anywhere. I'm sure there's a lot of good lawyers where you live, or any other place in the world. But just seek advice of a competent attorney before you make a decision. Don't rely on what we say here because we don't know everything about you.
Yeah.
With that, let's take the first one.
Now, I'll tell you, Sam, I had a consult with somebody today, somebody who had given some advice to in the past, sent me what they thought was a simple question. And, basically, I said, no, there's a lot more to this than you're thinking about. We really should talk about this. We talked about it. I basically saved his butt from getting stuck outside the United States or never being able to come back. It's really the sort of thing where the devil is
And that's a
is in
and
the
that's a
details.
where it really is important. Yeah, I've had talked to somebody who was bent out of shape to leave and come back, and it's like, what are you doing? Trying to say, well, there's better ways of handling things. But let's take the first one.
All right. From the Great
I,
Invisible.
I like that.
Yeah.
Not only is he invisible, but he's great. How can an invisible be great at the same time? Can you
I,
be invisible and
I
great
mean,
at the same time?
it's in the fun of the contrary language.
Yeah,
That's for sure. Not quite in oxymoron territory, but
but an
uh,
interesting one. So I
yeah.
became a green card holder in 2022 through EB2 Schedule A. Um, file follow to join for wife and kids approved in 2023. DQ June 2023. Still waiting for interview over 18 months in
Lagos, Nigeria.
Nigeria.
Yeah.
Is the writ of mandamus in order?
So if anybody was listening to Sam Reed and watching my face when I went, it's because I saw Lagos, Nigeria, and I said, of course it is there because it is in my
I had,
estimation.
I had a guy I talked to today.
Yeah.
He filed his adjustment in 2017, Brian.
Yeah.
It's 2025 and current.
Yeah.
Um, yeah, but
Yeah.
not everybody can afford it. So this gentleman can afford the writ of mandamus.
Well, yeah. I mean,
Is 18 months sufficient, Brian?
I'm inclined to say so. I have filed for less. The one I filed one. The facts were a little bit different. I was a family one, and I think this is maybe out of Lagos, maybe it was out of Nairobi. But bottom line is, across Africa, the consulates are at their absolute peak of slowness, I would say. But I
It
found
sounds
one.
like a combination of slow, overwhelmed, understaffed, and unorganized.
I would agree. Yeah, I would
Pick a
agree.
couple of these. It may not be all of the above, but pick a couple of them.
Hmm.
And uninspired and don't care.
Yeah.
So pick two or three of those that define some of the consulates in Africa that we've been dealing with
Yeah.
recently.
So I guess my very short answer to this question is the devil's in the details, right? But you're not crazy to ask that question, and I think it's a good conversation to be had about that because eight the way I can choose to portray this is documentarily qualified in June 2023, which means they've been sitting on this case for 18 months. You know,
I mean,
that's
it's a
yeah,
choice between being patient for another 6 months and making it a 2 year and having a little bit better case,
yeah,
or filing now and just because it's going to take normally what 2 to 6 months to resolve these.
yeah.
On the upside, 2 months. If it's back and forth, five six
Yeah, it's
months.
still going to take some time to do the
So
complaint
there's
and
that
execute service.
legwork,
Yeah,
file a complaint, and
yeah,
well, then they're gonna ask for the extension, and they're
yeah.
gonna contact the embassy, and then come back to you, and then and then they may file a motion in opposition. They may not. Sometime they will just get back with you in 6 months. They give us one more month, and it's resolved. 90 days, boom.
I
Done.
literally have one of those. I got one of those emails before I left on vacation, Sam. I sent a case I've been talking to everybody about in this office. I sent an email to our attorney. I said, "Well, we told the court we expect to have this resolved by January, and your client hasn't done anything." He said, "Well, I'm actively working on it, and it's."
So
I,
file a motion or
well,
summary judgment.
that's technically. Well, I'll spare you that
Yeah,
conversation. Technically, his deadline hasn't come yet,
I
to
see.
the best of my knowledge. But we stayed the proceedings, But yeah, I mean, bottom line, 18 months is. I usually tell anybody if you're coming out of Central Africa, you are probably going to be facing a longer time than normal. 6 months is perfectly normal, and happy with it if you're done in under a year. I'd say there's a conversation to be worth having on that one. Uh,
Yeah.
Bonus points if you're from Somalia, for example, because that's a country where I always find they take them longer, and I presume it's due to security concerns, due to a non-functional government there.
Yep.
You know, yeah, a good
All right.
question.
Yep. The Great Invisible gave us a good question.
Yes.
Wandering, I'm sure it'll be a better question. I filed an adjustment of status in September 2022. My company dissolved before it was pending for 180 days. I
Mhm.
think we had that last week.
Yeah.
Didn't
Well, not from this name though. I'm pretty good at remembering names though.
we? Yeah,
Yeah.
before it was pending 180 days.
Yeah.
Now I-45 is pending over 180 days. Am I safe to port job now? I-140 was approved more than 180 days, and I-140 was never withdrawn.
Now, last time, Sam, we sort of focused in on, what does it mean about your company going out of business, right? And this question, which again, I suspect might be the same person, used a more specific term, dissolved, company dissolved. And for me, Sam, and I read that word, I means company snuffed out of existence, no longer exists, right? And my short answer is, if your position is, if your company is dissolved under the rules, basically your I-140 goes away, right? And if your I-140 goes away within 180 days, so does your offer go within 180 days. Thus, I think that case has a problem for me.
It does have a problem.
It's again, the devil's in the details, but I don't. If the I-1, this says I-140 was never withdrawn, and this is when I bring it. I would say, have you heard of the concept of automatic revocation? And that's really what I think you're dealing with here. Is this an automatic revocation scenario of the I-140?
And the question is, would they discover it?
The question isn't. I mean, the problem. It's always a problem. If discovered or not discovered, it's a problem. I mean, you're right. I would ask that same question. That's what the client's going to ask me, and I'd say no matter what, you still have a problem,
Yeah.
which is a
If
gray cloud that can follow
wandering,
you.
yeah, if wandering, yeah, I mean, the problem wandering is having is if his priority date is becoming current soon, his window of opportunity to file a new perm, a new I-140 with a new employer is not, I mean, it's going to take him a longer time. But
Yeah.
yes, there's definitely an exposure in this case. And if USCIS find out that the company dissolved before the pending 180 days of the adjustment status filing, they can definitely deny that adjustment
Yeah,
status.
but I can't help but echo us of last time of it's really hard to dissolve a company. It takes a long time to wrap up the affairs of a company, and most companies don't, you know, dissolve. I'd say they're more likely to
But if
just
they had
stop doing business.
zero employees at the time,
Zero business activity,
prior
sure.
to 180 days, and bunch of lawsuit against them, this company is no longer offering the
Oh,
job.
sure. Oh, sure. I mean that. Well, no longer offering but they didn't withdraw the I-1. These are the devilish little details we can get into in a conversation with somebody about this. I guess. I mean, there's about 5 different ways to be concerned about this, and even if I guess you're saying, Brian, even if the company isn't dissolved but it's all over the news that says company goes bankrupt, fires all employees. Yeah, I agree. That's a problem, regardless. Yeah,
I mean, we can only look at the law, right, and the facts.
yeah,
The question, when it comes to whether or not USCIS is going to catch it, that's the roll of the dice.
yeah,
You want to go in with a 100% application, or you want to go with an application that has a small hole in it or a big hole in it, becomes the question. And if the question is, I want an airtight case, this case has a hole.
yeah. I consider it a pretty big one. Well, again, I don't know what is meant by dissolve here, but if the company truly no longer exists, I'd say, you're toast. But again, there's the devil's in the details as to what's going on there.
Or
Yeah,
as an attorney, you can just say, give me these details. What facts do I have? What facts are out there to support my position that this company remained in valid business
through the
until
required time.
180
Yeah,
days?
yeah, yeah,
And you can go out today and start collecting
yeah,
these type of information. And if you're able to collect it and build a case, you put that aside just in case it get asked 8 years from now, and you have the file. Because 8 years from now, you're not going to have the ability to reconstruct evidence that might be available today,
yeah.
and
You know,
that would be something that you can do.
Yeah, even so, I'm talking very negatively and about dissolution. But again, if it was dissolved when it was merged with another entity, it could be a successor of interest. Now you might have serious trouble arguing that if you're no longer with the business, and but that's
Well, yeah, it's a big problem because
it's a sort of thing though, Sam, where if you're looking for to say what do I have to say that this business went onward beyond so I can say it in good faith. The answer is, oh no, it wasn't. It was dissolved, but it was all the stock of it was bought up by company ABC. They absorbed everything, assets and liabilities, to the best of my knowledge. My I-140 continue. Hey, I got there.
yep,
Yeah,
yep,
yeah,
absolutely. So Wandering is adding on. He's saying, I
yeah.
don't see my priority date becoming current for a long time. So it's likely USCIS will find out my company ceased operation 1 month before I was eligible for portability. So if it's likely, and he's using the term here, ceased operations,
That's
which is
different.
completely different than, but
Can they
it
offer
could
good
be
faith in employment? Yeah,
it could be a difference, a distinction without a difference.
yeah. It sounds like
So
a great court case could come out of it, and I wouldn't want to find you in a court case. Wondering is the bottom line. And well, so what's your advice, Sam? If you think
I'd say priority date is not going well. You got a priority date, you got
yep,
plenty of time. Just go out and get yourself a new perm. Go ahead and take the position that my offer of employment and everything is valid. That's a good position to take right now. You can get your I-45, EAD working for you. Get a new labor certification, get a new I-140, and forget about this one and move on.
yeah, don't bet your money on it if you know
Yeah,
it's weak. I'd
yep,
say if you're still maintaining H-1B, well, keep maintaining H-1B, because if there's a existential threat to that I-45,
yep,
best to stay on H-1B. Yeah,
yep. All right. So we have a comment from MG, the public
MG,
announcements.
no
No
questions.
questions today. Thank you, MG. But thank you all for support and what you do. Have a great year ahead. Well, thank you. We appreciate it. We're
Yeah,
happy to help. We do this because this is what we do. We are professionals, but we also, our heart, we love what we do. And we enjoy this 1 hour.
Yeah.
with everybody and taking your questions. Hopefully, we can give some advice and some direction. And Brian and I get to talk to each other for an hour. We
Yeah.
don't do that if we don't do this
You know,
this
we
YouTube
sometimes
session.
do, but it's sometimes it's
Not a full hour.
not a full hour. Hour, you're right.
Never.
Maybe in little chunks.
Five minutes here, 5 minutes there, right?
5 minutes there. But
Yeah.
sometimes this is like the first time we get to talk because we have crazy Mondays. So
Yeah,
yeah,
absolutely. And Runyon, I believe, got
yes.
a question for us. With the new administration, immigration changes will cause any delays in processing regular EB green cards. Would it decrease resources for other immigrant visas? Speculation, speculation, speculation.
I've been asked this question literally earlier today, Sam, when I was talking when it's in the conference room with that family-based case we were talking about. You know,
What do you think, Brian?
what I will tell you exactly what I told that you met him, Sam, the nice fella. I said
Yeah,
yes, no, maybe. The answer is I can tell you reasons why it may. I can tell you reasons why it might. I can tell you what the experience was in the past, and my honest answer has to be we will wait. We will wait and see. We don't know what happens until it happens on this one. I mean, the best thing I tell people, the best way I can judge this is go by what happened during the prior Donald Trump administration, and I can't really say that the slowdowns at USCIS were something I was terribly worried about in terms of normal processing times. Some processes were monkeyed with. The classic one was the H-4 by adding in a biometrics requirement, and that really slowed that down. But generally speaking, processing times didn't go away. USCIS is funded by their fees. They didn't
Trump
have
said I like H-1B.
yeah, yeah,
He before wanted to kill H-1B.
yeah,
As H-1B was on life support during his tenure,
yeah,
has rebounded and got some health. Now he wants to befriend H-1B. That's good. That's good
yeah,
news. I
yeah.
mean, the guy is a pragmatist, right?
Is he? I don't know.
Uh huh. Well, I got a call from my daughter here as I'm doing my YouTube session,
Yeah.
and now she's shocked. I'll be talking to you later.
Did you? So Sam, did you try to push the ignore button and push the wrong one? Is that fair
No,
enough?
it's okay. It's a good trick for her because she's now laughing.
Yeah. Well, yeah. Well, I
She
presume I,
should go back and watch it.
I presume at home, Sam, the whole family is just
She's not at
glue,
home. She's
glue,
in Boston.
well, wherever they're at any time, just when they know it's 6 o'clock, they're just all here in their audience watching us
Yeah, right.
diligently.
Absolutely,
Uh,
absolutely, they do.
Anywho, so I think Ranjan, it's not going to surprise. Sorry, Ranjan. I don't think we're going to be surprised if we see slowdown, but it's the sort of thing where, in the past Donald Trump administration, I can't really say slowdown in processes was my concern. It was more changing wishy-washy standards was what I was really
The
more worried
slowdown can
about.
be very painful too, Brian.
Oh, I mean,
Um,
it's already painful. Everything is slow. Yeah, for sure. Yeah,
I don't know if he's going to prioritize. I mean, he cannot dump employees. The new agency he created that cuts fat,
yeah.
that is irrelevant to USCIS because it's not funded
Self
by taxpayers.
self funded by their filing fees. Yeah.
Yes. So that's good news. It's not on their target.
Yep.
The problem with that concept, of course, I don't care whether it's Democrat or Republican, there is no call for efficiency. There's no need to put pressure on these people to do their job better because it's out of the poor guy's pockets. And because of that, there's nobody saying, you guys are spending, you're charging people, what's the filing fee? 2000 or $1,440 for an adjustment application that takes 45 minutes to do.
Yeah. And their
Nobody
response is,
says that.
well, we're getting the work done eventually. Yeah.
And they're a year behind and they're working remotely from home.
Yeah.
And so can it get slower than this? That would be pathetic. And remember, folks, read the mandamus. Filing lawsuits against the government is the only remedy. And obviously, the course is getting a lot of these recently.
Yeah. We've been
We're
seeing
getting a lot of these
more. Yeah.
recently.
Yeah. Yeah.
They're not cheap, but people have had it. People wait. And
Yeah.
Runyon is concerned. He's concerned that his case is going to be delayed because nobody cares about efficiency in these
Yeah.
agencies.
Well, I always think the idea of a mandamus in employment-based immigration is always a little bit more interesting, especially for Indians with the priority dates been back and forth over last year. Because I'm in the midst of a mandamus suit right now. They're saying we've only delayed this case. It's only been 9 months. No, it's been 9 months since the interview, my friends. It's been 2 years since my lady's
Five
been
years
Yeah, it's been
since
it's
since the,
yeah, it's been you've had the case. I'm literally you read this memorandum I wrote, Sam. It's you've had the case since like 2022. She's
yeah.
been documentally qualified since 2023, and you interviewed her only 9 months ago. Meaning, pick, and now it's 10 months. Now it's a year, and pick one, but all of them are a long time, guys.
Yep.
So yeah, yeah.
All right. So next one, Brian.
Rasu ready.
Yes.
An H-1B extension is currently in progress. What will the new rules taking effect on January 17th, 2025 apply to applications filed before that date? Um, Sam, somewhere that's probably going to be written into these regulations is the bottom line, right?
These regulation number one. I mean, so everybody understand.
Hmm.
I would say they will not apply prior to cases filed prior to January 17,
Yeah,
2025. Because if I file today an application for
I
an
got you.
entrepreneur
Yeah,
H-1B, I'll get it denied. They'll deny it. They'll say you filed it too early.
yeah,
The law was not in effect. On
yeah,
January 14th, when we received it, we could not adjudicate it because the law was not in effect.
yeah.
So I would say the law will not be applicable to cases filed before the effective date.
Yeah, yeah, that's got to be true because I know that there's supposed to be a new version of the I-129 form coming, which is effective to be available soon to implement the changes, which probably includes a bit about, oh yeah, by the way, against site visits are compulsory now. I imagine something like that, and that version of the form is not out yet. Other things in the regulations, like one of the things we didn't talk about earlier, was that maintenance of status records are mandatory now, right? And they regulate that, and basically, well, if that wasn't, how can they hold you to standards and we're that's a fair
Yeah.
answer.
Yeah. All right. So
So
we have tech topics.
with a procedural complaint, I'm not taking offense at a tech topic. So, hi Sam, looks like my questions on the top of chat got missed. So at the top of our chat, I do not see those questions, tech topics, because perhaps you put them in before we went live, and sometimes the ones we put in before that come in before we went live don't make it here. But
I
it
see.
does,
I see
yeah,
some questions here. So
yeah.
everybody, just kind of a forward look into 2025, and I have a meeting. I think this Thursday, which I may have to move until to Friday.
Mhm.
We are potentially rolling out immigrationquestions.us.
Oh yeah, you're going. Okay, you're announcing that. All right.
Well, we're not. We're just talking about it. So we are rolling out immigrationquestions.us, where you guys can post your questions during the week, and we will
We'll
take
answer
some
them.
of
Yeah,
them. Yeah, we'll take some of
yeah,
them into the session. It provide a forum to put your questions. That's basically the thought behind it, because you could be on Wednesday working. They go, that's the question. Let me put it here for Sam and Brian, and
Oh, okay.
we'll go in and answer them.
Well, so you said you're talking about it, Sam. I'm just going to elaborate. Immigrationquestions.us is http://immigrationquestions.us, and that's a website you have registered. And I see it. I see it now, Sam. I've gone there. It says launching soon, so you have a landing page there. So the theory is this is a website where somebody could come in the midst of a week and pop in a question there, and the Sams and Brians of the future will be able to go ahead and check those out and answer those questions as part of our YouTube weekly
YouTube,
sort of
yeah,
thing.
and then
Yeah.
and if it takes doing one more YouTube, maybe we'll do even more to provide more opportunities. So that
Yeah.
is the response to Tick Topics. However, Tick Topics has questions too
Yeah, Tech
that
Topic
I see.
was so kind as to repeat them.
Yeah,
We'll get that in here. So, a three-parter. I filed compelling circumstances EAD after unfortunate and retaliatory termination on October 25th, B2 on December 6th, and um,
F1 premium processing on
yeah,
December 1st,
yeah,
2024.
yeah, okay. My B2 was approved on December 20 something, 2024, and F1 is approved on December 30th, 2020, 30 something, 2024. We got RFE and compelling circumstances EAD on December 18th, 2024, which is yet to respond. Okay. Now, my F1 is approved and EAD got approved on January 6th, 2025. Questions. Does approval of EAD void my last approved F1? If not, can I attend F1, college on F1, and work on EAD concurrently? What a great, fun little question for us, Sam.
But you're not going to give him a great fun little answer. You're going to disappoint Tech Topics.
I thought I was going to allow you to disappoint Tech Topics.
No, you take the lead on that one.
Okay. So Tech Topics, the short answer is, well, there's two questions here. Does an approval of the EAD void my last approved F1? No. If not, can I attend college in F1 and work on that EAD, the compelling circumstances EAD concurrently? No. So F1 status has rules. It has rules for when you can work and when you cannot work. If you, the rules are generally there's on-campus employment, there's CPT, there's OPT, there's pre-completion OPT, post-completion OPT, and STEM OPT. That's a pretty good summary of what the available F1 work authorization. If you're not working on one of those, you're not working pursuant to F1 status, and thereby you're in violation of your F1 status. So if you have a compelling circumstances EAD, and you pick it up and say, I'll use this while I'm on F1 status. Well, you're not going to be on F1 status anymore. You're going to abandon that F1 status to be in a wishy-washy period of time that allows you to stay in the United States and work pursuant to that in compelling circumstances EAD. But as an aside, congrats to Tech Topics on getting that compelling circumstances EAD approved.
Good. Right?
Yeah.
So which one would you recommend for him to pursue, Brian, and why? Question Tech Topics didn't ask, but a question worth asking in this situation because the answer may surprise him.
Yeah. I don't think the answer, at least from, I know what my answer is going to be. So my answer is what I've told people in the past when talking about compelling circumstances EAD. I don't like it because it puts you out of status in the United States. If you find yourself with an opportunity to say, I don't know, take an H-1B job, Tech Topics, you would be forced to leave the country, get a new visa, and re-enter the country in order to take it and get back on H-1B status. And that, for me, stinks.
So you get 1 year.
I believe that's what you get, yeah.
And you can renew it.
Yep.
What's the likelihood the Trump administration will renew your EAD application?
Well, Sam, every case is different. I don't know. Tech Topic seems to have a very compelling case. You know, retaliatory firing. I love it in terms of a compelling circumstances. I don't like it for him or her. But I guess what I would say is there was already a bit of I'm going to call it a stink on the compelling circumstances EAD in that they were approving very few of them. The program was ill-used, and I am compelled to believe that it will be less favored. They have some really broad policy that favors the issuance of compelling circumstances EADs right now. I can't help but think that would be ripped off the USCIS website. As I recall, Sam, the scenario is like, hey, if you've been in the United States for a long time, own a home, and have some U.S. citizen children, we're going to consider that. That sounds like a compelling circumstances to us. And I think basically they can't get rid of the regulation. But this is the magic of policy. They can sure change what they think is compelling. And I think they'll think they'll be less likely to think your request is compelling, especially after a year. After a year, you could have gotten another job, my man. You can't be in compelling circumstances territory forever. You know,
right?
Yeah, I haven't looked at the statistics for compelling circumstances EADs for a long time, but I can't help but think the renewal rate's a heck of a lot less than the initial grant rate for sure.
RK is asking you, do you see a policy to stop issuing 5-year EAD and advanced parole?
What do you think, Sam?
Yeah, I can see that. 100%. I can see it because it's a kind of more an enforcement-minded group of people right now, and giving people 5-year is not something they're going to be comfortable with. I don't think.
If the narrative out there is, you're giving our jobs to foreign workers. The answer, I don't think any sort of narrative where they're giving out 5-year unlimited employment authorizations is one that they want to be a part of.
Yeah.
But it remains to be seen. All that is, I mean, it's a policy written on a USCIS website that appeared one day that said, "Hey, we're going to start giving out these EADs."
Yeah.
You
And
know?
that can disappear.
Yeah.
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 Would USCIS consider a company dissolved if it is merged into
Successor
S successor and
in
interest
interest
entity?
entity. So
That's a good legal question.
yeah.
Um, a merged company is a merged company. A dissolved company is a dissolved company. Um,
Yeah, but you're attaching legal terms of art to a question that is, I don't think
well,
anything
but
really.
but these terms are terms of art.
Yeah.
I mean, when you merge a company, um,
There's some,
when you merge a company, it may not be dissolved. The company that you've merged into can maintain their tax ID number.
yeah.
But if it's merged and it disappeared, ultimately that tax ID, basically what defines an entity is their tax ID, right?
Yeah.
Um, Consider it a name. The name of the company is their tax ID number, just to
Yeah.
kind of simplify it.
Sure.
So when you go in and you marry up with another company and you take on the name of the entity you married, that old name, that old entity is dissolved. But if you survived and your tax ID number survived,
Oh
that
yeah.
and
Yeah.
they did not
Okay.
dissolve.
So you're describing one scenario where two companies are merging together, and just because it's what it see, I guess what you're saying is sometimes it isn't what it seems. Sometimes if you perceive the company that you perceive to be gone is not necessarily the one who's tax ID who that goes away. Sometimes you get surprised by
Yeah.
which company gets not merged out of existence, who abandoned or eventually not dissolved, but merged out of existence.
The
Right.
key, the clue, because obviously as employees we don't know what's going on. We don't know
That's
the
the
legal
problem. Yeah.
documents. Yeah.
Yeah.
And for immigration law purposes, the key is whether or not these companies are small or big. The big companies, you can do a little bit of research and you can find out what the heck happened,
There's press
because
releases, that sort of thing. Yeah.
press
Yeah.
releases, if there's
Public. Yeah.
investors,
Yeah. Yeah.
there's
Yeah.
some public pieces that are public.
Yeah.
Small little companies can do tricky things and you have no idea what's going on. Oftentimes they do dissolve and they start new companies.
That's true. Yeah.
It is the more the norm than the exception.
Yeah. The last one major one I can think if we did was there is some companies that got bought stock purchases. Some that got abandoned the entity, bought assets and live. Yeah, it can be a bit of a mess
Yeah. Yeah.
there. So
So, in terms of you trying to figure out what's going on without the company communicating with you, leaving you out there on the lurch, trying to figure out what your future is, very unfortunate situation, of
yeah.
course. But if it's a small company, there is absolutely no benefit in merging. Basically, these switches are shut down. Start this company because this company has too much liability. There's unless the company has an asset of some value, like they have a product that's and has a client and producing revenue, and therefore merging the company makes sense. But if it's a simple IT company, there's absolutely no benefit for them to do that. So oftentimes it's dissolved.
I don't. Well, but so we've experienced where the company just gets bought. They buy the stock. They buy the stock from the existing owner, and they just keep it operating as a separate entity from the
Because
rest.
they have an asset.
Yeah.
In our case, that we just done recently, you and I, Brian, the company has an asset, a big asset
Yeah.
that we're trying to preserve. When that big asset disappeared, then
Well,
it
yeah.
becomes irrelevant.
I agree that eventually that those if it's I guess this comes back to the devil's in the details
Right.
because company A owns company B, but sooner or later somebody says we don't need to have company A and company B, and once company A buys company B, well, they have control of company B, and thereby they have control of the asset, the asset. But suddenly, somebody eventually says, "Well, we don't need two companies," and eventually, sooner or later, yeah, company B will hand everything over to company A is the likely eventual scenario. But again, the point for wondering is it's really hard to know. There's does company yeah does company B stop operating at all, or does it, or is it continuing on, or is it
which is the kind of thing that leaves people out there not knowing what to do with their future because the door shut down.
yeah. And the
I
problem
mean,
is
yeah,
for wondering when that theoretical noid comes in, there's no way to do it. Your argument is, well, no. See, the company continued beyond 180 days. The answer is, well, the burden's on you, my friend.
yeah,
And yeah,
yeah.
yeah,
With that, we conclude our 7 o'clock. We hit the 7 o'clock. Conclude our 1 hour session. Hopefully, it was helpful today for everybody. From Shihab Burke, you guys have a fantastic rest of the week.